Hi everyone, today we're going to be talking about civil suits and the process within the state of Michigan for filing, litigating, and winning. I'm Muthu Veerappan. I'm a criminal defense and civil litigation attorney here in Detroit, Michigan, and I help people fight for their freedom and protect their future. People file lawsuits for a variety of reasons. Sometimes it's a real estate or landlord-tenant issue, other times it's a personal injury or breach of contract dispute. Regardless of why you're filing, the judicial system wants to process the lawsuit quickly and efficiently. The first step is the summons and complaint. The complaint explains the facts of the lawsuit and the relief that you're requesting. If the complaint is accepted, that means that you are the plaintiff. The court will issue a summons. A summons is a piece of paper that notifies all the parties when and where to appear. The second step is service. The parties you are serving must be served with both the summons and the complaint. You must file a proof of service with the court after service is complete. If you're unable to serve the summons and complaint on one of the defendants, then you have to file a motion for alternative service. When the court hears your motion, you can argue to serve the defendant by email, posting it at their last known address, or by publication in a local newspaper. The third step is answering the complaint. A defendant must answer the complaint in a timely fashion. The summons has a deadline to answer the complaint. If a defendant fails to answer the complaint, then a default judgment can be entered against that defendant for the relief listed in the complaint. For example, I sue John Doe for $250,000 and I properly serve him. John Doe receives the complaint and summons and he goes and puts it on his desk. He forgets about it. 28 days later, I go back to the court and I ask the court for a default judgment. Now, I can chase John Doe for the full amount by garnishing his wages and selling his assets. Now, John Doe can always file a motion to set aside the default judgment, although he would need something called good cause for that. The fourth step is pretrial. This is the first step of the litigation phase, and you only arrive here if the defendant files their answer to your complaint. This phase is also known as discovery. It allows both parties to gather facts that help them prosecute or defend the lawsuit. The Michigan Rules of Civil Procedure act as guidelines throughout the litigation process. During this phase, the parties engage in written and oral discovery. If you violate the rules of civil procedure, then you may be subject to serious consequences. An example of this is failing to file discovery responses within 28 days and having a court order you to pay the other side's attorney's fees. The court could also dismiss your case, so it's important that you hire an experienced attorney. The fifth step is alternative dispute resolution. 97% of all cases settle in the pretrial phase. During alternative dispute resolution, the parties can attend one of four options: case evaluation, mediations, facilitations, and arbitrations. The sixth and final step is trial. If you can't settle the case, then each side presents their facts and evidence. In a family law matter, this would be a bench trial, so only the judge would be the finder of fact and law. Otherwise, a civil trial will likely have a jury that will act as a fact finder. This entire process can be overwhelming and missteps can cost you. But we're ready to help you. We're open 24/7 and I'll give you a free consultation. You'll sit with me and we'll review your case and see what options you have available.
This video is not legal advice and should not be relied on for legal advice. Be sure to consult with an experienced attorney whenever you have legal issues.